Good afternoon, everyone. So as Jessica mentioned, I'm Dr. Diana Naderi, and we're going to be talking about advanced directives and advanced care planning. And we'll be providing a CE credit for those of you that are attending and follow up just as Garcia described. So here's some information about the CE provider, which is us here at VITAS. I personally have no other disclosures to advise. As Garcia mentioned, I am also the medical director for ONEgeneration, and nothing else that I have to disclose. So our goal today is to educate healthcare clinicians about advanced directives and advanced care planning, as well as serve as a support for those individuals. And sorry, let me just move this from my screen over here. So we're going to review the origin and the meaning of advanced directives. We're going to go over what the definition for advanced care planning. Hereafter, you may see in a lot of my slides that it says ACP, which is referring to advanced care planning. And we're going to identify the types of advanced directives and their function. And also, I will go over some ways to guide you if you are initiating these conversations on advanced directives, as well as resources that are available. So I'm going to start off by first saying the definition of advanced care planning from the National Hospice and Palliative Care Organization, or NHPCO, which they describe and define advanced care planning as making decisions about the healthcare you would want to receive if you're facing a medical crisis. These are your decisions to make regardless of what you choose for your care, and the decisions are based on your personal values, preferences, and discussions with your loved ones. So one of the things to really think about especially is what do people want at the end of life, and how do we ensure that it happens? So communication is the most important part of advanced care planning, definitely making sure that there is frequent and ongoing patient-clinician conversations about end of life. Hereafter, you may see it listed as EOL in some of our slides. And we're looking at end-of-life care values, goals, and preferences. So these conversations among patients should also include the loved ones, as well as the healthcare team. And consideration should be made of the patient's relationships, as well as their culture, to really dive into what are the end-of-life treatment options and what decisions can be made about care preferences. And then beyond having the conversation, having these decisions recorded in an advanced directive. But I always like to say the most important thing is the conversation and to have it ongoing, because at the end of the day, it could be written on a piece of paper, but if you didn't share it with anyone else, then there's going to be a lot of frustration, a lot of emotions involved in trying to honor that. So there definitely needs to be support throughout the disease process for people, helping people at any age or stage of their health understanding and sharing their values, goals, and preferences regarding future care. I like to say that everyone over the age of 18 should have an advanced directive, or at least have had ongoing conversations, because while we oftentimes, and we'll talk about this more in upcoming slides, bring this up for patients who are gravely ill or experiencing the end of their disease process, any of us could have some kind of catastrophe happen tomorrow. So at the end of the day, everyone really needs to have these conversations well in advance of having some kind of significant disease process. And obviously updating it and continuing to have those ongoing discussions as preferences may change. And the discussion goals and timing can vary. You know, it's based on a person's health, values, culture, and a lot of different factors. But even before some kind of life-altering disease process starts, it's definitely important to still have that conversation started sooner rather than later. So VITAS actually did a survey in 2021 where they found a growing interest in talking about end-of-life wishes. So this was done among 1,000 people in the US in the month of March of this year. So during, our part of our 2-year pandemic we've been experiencing so far, essentially. And 69% of consumers say that discussing end-of-life wishes is important, and 56% have done so. 32% have documented their wishes in writing. So Thankfully, that means a lot of them are reflecting exactly what I was hoping for, which is at least having the conversation. But as you can see, there's a far smaller number of people who actually record their wishes in writing as well. 29% said that the pandemic increased the likelihood of documenting their wishes, and 20% knew someone who was seriously ill or died during the pandemic, but they didn't know that person's wishes or values. And that can cause a lot of distress to the family, to the loved ones. And this is something that was an issue even before the pandemic. I mean, in my experience doing inpatient palliative care consults in the past, it was always that topic that came up of, you know, mom never told me what they wanted. You know, my brother never talked about this. And that's where it's really important that that is not something that we want to hear in the crisis. We're hopeful that everyone has had these kinds of conversations beforehand. So of those 32% that actually documented their wishes in writing, they did find that this was more likely among men than women, among higher age and higher income, and among white rather than non-white respondents. So just giving you the breakdown of some of those responses that we got. So the same poll was looking at key benchmarks for triggering advanced care planning conversations. So 55% at a certain age, 22% when the physician came up. But I think it's more important to even see the common barriers to the conversation. 42% said, I'm not sick or dying. 26% said, it's depressing to think about. And 23% said they don't even know how to create a plan. So it's important to have this insight into these different aspects that are barriers, because if we know the barriers, we can address them so that we can help to improve them. So why is ACP important? Well, many people nearing the end of life are unable to make their own care decisions. So having these conversations well in advance is a great way to have that insurance when it comes about to the type of end of life that decisions need to be made. Of people who indicate that their end-of-life care preferences, most of them choose care focused on alleviating pain and suffering. So in that time when they're having some kind of terminal diagnosis, when they have an incurable condition, most of the time people will say at that point, they want to focus on comfort and palliative management when they're being asked. But again, if that conversation never happened, the loved ones and family members can oftentimes have that unclear certainty of, is this really what mom would have wanted? The primary objective of advanced care planning is to ensure that patients receive care that aligns with their goals and values. And in 2018, 31% of patients in the US died at home. But surveys have shown back in 2018, and I'll tell you this number is pretty similar every year, that 71% of Americans, when they're asked where they would like to die, say that they want to die at home. One of the barriers that also can come up, though, is the clinicians aspect of initiating these advanced care planning discussions. They have the responsibility to start them, but they're often uncomfortable, they're not trained very well, or they're just too busy. They're not able to fit enough time into their busy clinic schedules or during their daily rounds in the hospital, because it can take up a lot of time. There's also a lack of knowledge among the public of the purpose of having advanced care planning discussions and how the procedure actually comes about, like what are the steps to discuss advanced care planning as well as recording your wishes. Most patients express a desire for having an honest conversation, but they wait on the clinicians who are involved in their care to actually start the conversation. So having this lack of concordance with wishes and care provided at end of life can really create a problem when it comes to end of life. So in a review of looking at 150 studies in the United States, 36.7% of the population had completed an advance directive, 29.3% had completed a living will with stated wishes for care, 33.4% had appointed a healthcare power of attorney. Ill persons are more likely to have completed documents than healthy persons, although it's not by very much. It's 38.2% versus 32.7%. And patients over the age of 65 are significantly more likely than younger adults, a comparison of 45.6% versus 31.6%. And really looking at the study that reviewed these 150 different studies, that's not even half the population when we're talking about these numbers. All of these are well under half the population. So there was another study in 2013 that showed that even fewer patients had a conversation with their healthcare providers about end of life, only 11%. And only 22% of those ages 65 and older had a conversation with their healthcare provider. This is very, very little. So this study was reviewing a question that was done about how comfortable would you be talking about your own end-of-life medical wishes with each of the following. So as you can see here, the dark purple showing very comfortable. There's actually a significant number who felt very comfortable with sharing these end-of-life medical wishes with their spouse or partner, with a doctor or other healthcare provider, with their children, with their parents, and with a spiritual advisor. So if everyone feels so comfortable, why is it not happening? On the flip side, this survey and study was done with respect to physicians and how they felt when it came to advanced care planning. So in the first figure, we're looking at the response to the question, in your own opinion, as a healthcare provider, how important is it that healthcare providers have advanced care planning conversations with patients? And we can see here, 51% felt it was extremely important. 38% felt it was very important. So if the healthcare providers feel that it is basically almost 90% important, why aren't they doing it? And in the same study, the percentage of respondents who support the new Medicare benefit that's paying for the advanced care planning conversation, they overall, as you can see, strongly support the new Medicare benefit of paying for advanced care planning conversations. And I think that number, 95%, is up. So please ignore that. Just look at the pie chart. All right. So with knowing about all of these barriers, there's definitely a lot of opportunities. And educating and training clinicians is one of those opportunities. That's something that's my mission, especially as somebody who's out of training, out of residency, out of fellowship, is really going back to those residents, going back to the learners, the medical students, and helping to support and educating them as our future physicians in the community to feel more comfortable about having these conversations. And also to remember to utilize members of an interdisciplinary team. It really shouldn't fall on the physician alone. You know, especially with the previous slide talking about how there are many who feel comfortable sharing with their spiritual counselors. This is where in a hospice or palliative care team, there's often a chaplain involved, and that can make a difference for patients and families to feel more comfortable in having these discussions because they feel more comfortable with a spiritual care advisor. But there's also members such as a social worker on a team, there's nurses on a team, and all of them together can provide valuable insight that can help for the patients and families to feel more comfortable in sharing their opinions on what they would want. Public outreach is also something really important. There are systems also in place as far as in the hospital setting, and even I think in the clinic setting sometimes, healthcare providers can document their advanced care planning discussions with a template. There's even electronic medical record reminders. Did you discuss advanced care planning? And of course, now there's the reimbursement for advanced care planning. Speaking as a clinician in the community, I will tell you it is not the best way, but at least it's a start because before we didn't have these kinds of reminders for my colleagues in the community to even think about having these conversations. So this is a diagram from a recent study that showed that nursing home residents increasingly opted for do not resuscitate and do not hospitalize options after they had advanced care planning conversations with their healthcare practitioners during the COVID-19 pandemic. So it was a really huge difference once the healthcare providers were involved. Another study from the West Virginia Center for End-of-Life Care noted a new sense of urgency regarding advanced care planning, comparing the first 6 months of last year to the first 6 months of the previous year, there was 9.05% increase in advanced care planning form submissions overall, 77.18% increase in DNR cards, and 45.95% increase in the e-directive registry sign-up, which is an electronic advanced directive registry that they had in this study. So this is from a landmark study that was published in the New England Journal of Medicine in 2000 that was saying that living wills were associated with increased odds of receiving comfort care. So subjects who had appointed a durable power of attorney for healthcare were less likely to die in a hospital or receive all curative, aggressive care possible. Among the subjects, 42.5% needed decision-making about medical treatment before death. And in this group, 70.3% of subjects lacked the capacity to make those decisions themselves. And what happens when someone lacks capacity? The family, loved ones end up making decisions for them. So in short, 29.8% required decision-making at the end of life, but lacked decision-making capacity. These findings suggest that more than a quarter of elderly adults may need surrogate decision-making before death. And if there isn't an advance directive already in place or some kind of durable power of attorney for healthcare in place, then we start to get to the point of the default in the hierarchy depending on the state. There's been a concern among the healthcare community that talking about advanced care planning will cause distress. But this was actually disproved in this landmark study in the Journal of American Medical Association, which was in 2008, and it shows that this was disproved, and it continues to be true. Advanced care planning also supports patients to accept their illness, determine their wishes, and document them, which we're going to see further on the next slide. So with discussions about end-of-life care, twice as likely for these patients, they're able to accept their advanced diagnosis. They're also twice as likely to be opposed to death in the ICU setting. They're 3 times as likely to complete a DNR form, and they're almost twice as likely to complete a power of attorney form. By having these conversations with the patients, it's really giving a sense of control back to the patients and offering some kind of hope. Hope that when that time comes, because at the end of the day, we are all terminal, when that time comes, at least they can have a voice now as to what their treatment preferences would be. And it's been shown through this study that they are not associated with physiological distress compared to those who do not have end-of-life discussions. So some studies show that advanced care planning conversations can improve multiple outcomes. There are fewer hospital admissions and intensive treatments at the end of life. There's an increased enrollment in hospice, greater likelihood of the person dying in the setting of their choice, as well as increased satisfaction. And a 2017 outcome review study was unable to determine if advanced care planning impacts end-of-life care, and concordant care ranged from 14% to 98%. Overall, it's just been very challenging to study the effects of advanced care planning. There's a lot of heterogeneity, and there's also very few high-quality studies. So we do need to have more, and this presentation is really going with what we have to work with, but there's definitely opportunities still available for studying this further. So with respect to the history of advanced directives, so actually documenting what these advanced care planning discussions and conclusion of treatment preferences are. Advanced directives are a product of the patient and consumer rights movements of the 1960s and 1970s, when the U.S. Supreme Court established that patients have a constitutional right to refuse life-sustaining treatment, the right of refusal. The courts gradually decided that withdrawal of care was morally equivalent to a patient's refusal and extended these rights to patients without decisional capacity through their healthcare surrogates. So end-of-life issues have long been the focus of intense societal debate, where essential questions concerning patient autonomy, quality of life at the end of life, and withdrawal of life-sustaining treatments are considered. And in fact, as far back as 1914, case law established the requirement to attain a patient's consent for invasive medical procedures based on the right of self-determination. So by the time the 1960s came around, there were a lot more of these patients in consumer rights movements and actually hospice care advocates, because the first modern hospice didn't come about until the 1960s. So that helped to support the movement in having patients have this autonomy and really determining what their wishes would be ahead of time. So together, having these patients in consumer rights movements as well as the hospice care advocates really led to what we now call the living will. And it was something that really came about actually with the states rather than the federal government to give legal support to this living will document that we now all pretty much know and know many people who have. In 1990, though, Congress enacted the Patient Self-Determination Act, which we're going to talk about in a couple more slides. This requires most healthcare facilities to actually ask patients whether they had advance directives, as well as for the healthcare facilities to provide written information on rights to make treatment decisions to adult patients on admission or enrollment to a healthcare facility, and to make advance directives forms available to patients who did not have one. So I know many of you, if you've been to a doctor's office recently, if you've been in the hospital recently as a patient, you probably got a stack of 20 pages. It included actually these things that I'm describing. So this came about from that Patient Self-Determination Act. It was designed to acknowledge a patient's right to either refuse or affirm medical treatment, empowering patients by safeguarding their autonomy and preserving the self-determination, protecting patients against maltreatment, fostering communications between patients, their physicians, their healthcare providers as part of the team, and also protecting physicians from litigation in end-of-life decision-making. So now that we've talked about the PDSA, the PSDA, the Patient Self-Determining Act, we're going to talk about a couple cases. So I'm sure a lot of you are familiar with the cases we're going to be talking about, and we're going to start with Karen Ann Quinlan. So Karen Ann Quinlan, on April 14th, 1975, after an evening out with friends during which she consumed alcohol and sedatives, the 21-year-old New Jersey resident stopped breathing and went into a coma. After 5 months, doctors diagnosed Quinlan as being in a persistent vegetative state. Her parents, who believed there was no chance of her returning to her consciousness that she was in before all of this happened, and who really wanted to just end her suffering, had stated that they would like to have Quinlan be disconnected from the machines that were sustaining her. Her doctors refused. So then the parents took the case to court. This became one of the first right to die cases in US legal history. Based on the right to privacy, the court ruled that no compelling interest of the state could compel Karen to endure the undurable, and they allowed her to be taken off of life support. Her story made headlines and provided the groundwork for numerous similar cases, but Quinlan's story didn't actually end there. She got weaned from the respirator, and she survived 10 more years before she ultimately died of pulmonary failure on June 11, 1985, in a New Jersey nursing home. Our second case is Nancy Cruz, another very well-known case. On January 11, 1983, at the age of 25, Cruz had a wreck on a country road in the Ozarks of Southwest Missouri, and she was thrown from her car. Paramedics found her with no vital signs, but they resuscitated her. After 3 weeks in a coma, she was diagnosed to be in a persistent vegetative state, and surgeons inserted a feeding tube. On October 23, 1987, almost 5 years later, Nancy Cruz's parents, Joy and Joyce Cruzan of Caterville, asked Jasper County probate judge Charles Peel for a judgment that they allowed to have Cruz's feeding tube removed so that she can die as they believed that she would want. Almost 6 years later, July 27, 1988, this judge, Teal, issued a judgment authorizing the Cruzens, acting as Nancy's legal guardians, to request the withholding of food and water from their daughter. On November 16th of 1988, in a 4-3 decision, the state Supreme Court overturned the lower court's decision, holding that there was no legal authority to grant the parents of Nancy Cruz's request. So then the family appealed to the United States Supreme Court. On August 30th, 1990, Cruz's parents asked Judge Teal for a second hearing, saying that they had new evidence that their daughter once indicated to 3 people she would rather die than live in her present condition. On December 5th, 1990, Cruz's court-appointed guardians recommended the feeding tube be removed so that Cruz may die. December 14, 1990, Judge Teal ruled that Cruz's parents can remove the feeding tube that has kept her alive for 7 years, ending the landmark legal fight over the right to die. Cruz ultimately died 11 days later on December 26, 1990. And our third example, another very well-known case, Terry Schiavo. So this is a highly televised and very controversial case, and started on February 25th, 1990, when 26-year-old Terry collapsed at home in the early morning hours, and she was rushed to the hospital where she was intubated and ventilated. Medical records indicate a diagnosis of hypoxic encephalopathy, brain injury caused by oxygen starvation of the brain. In June of 1990, Michael Schiavo, Terry's husband, was appointed the plenary guardian by the court. In July 1991, Terry was transferred to a nursing facility where she was briefly provided physical therapy. On February 14, 1993, Michael Schiavo and Terry's parents had a disagreement over the course of her care and the use of her trust fund to provide the therapy. In May of 1998, Michael Schiavo filed a petition to withdraw life support. Terry's parents opposed, and the court appointed a second guardian. In January of 2000, as support for his petition to withdraw life support, Michael Schiavo testified that Terry had actually told him in the mid-1980s that she would not want life support after the couple had watched a movie depicting a patient on a ventilator. Given the lack of a living will, a trial was held to determine what Terry's wishes would have been. Terry's parents continued to challenge Michael's guardianship. In 2001, Terry's parents filed a motion that included new evidence of Terry's wishes. They also filed another motion claiming new medical treatment was available. In 2003, Terry's feeding tube was removed for a second time. On October 20, 2003, a special session of the Florida legislature was called, and the House and the Senate both considered and passed a bill into law. This is now known as Terry's Law. This new law afforded Governor Bush the authority to order the reinstatement of Terry's nutrition and hydration, and the appointment of an independent guardian ad litem. In 2004, the Florida State Supreme Court overturned the law as unconstitutional. On March 18, 2005, Terry's feeding tube was removed for the third and final time. And almost 14 days later, on March 31st, 2005, Terry Schiavo died. Now we've seen 3 very famous examples of patients who did not have advance directives. So we're going to talk about what are advance directives and how can we prevent cases like the ones that we described. Advance directives are legal documents that allow patients to formally state their choices about what actions should be taken or not taken regarding their health in case they are no longer able to make decisions for themselves because of lack of capacity, inability to communicate, or lack of ability to make informed medical decisions. Advance directives become legally valid as soon as they are signed in front of the required witnesses or notary. They don't go into effect unless the patient is unable to make his or her own decision. Thinking of the fact that if a person is able to make his or her own decisions, they can override whatever it says in the advance directive. Each state has its own advance directive form. I personally have a favorite that I use that comes from Stanford because there are a lot of different ways that they can write out an advance directive, but the one that they use in Stanford is actually made for an elementary school reading level. And that's very important, is to make sure that whatever form that you have is something that's very easily interpreted by whoever is reviewing it and ultimately completing it. Changes to an advance directive should be recorded and given to the appropriate clinicians as well as the proxy. These need to be reevaluated yearly as well as needed. Choosing not to have certain life-sustaining or aggressive medical treatment is different from refusing all medical care. And that's something that I think is a very common misconception in the community, because oftentimes when it comes to reviewing advance directives, especially if patients and families are very concerned about, the fear of dying or talking about dying, keeping in mind that we're talking about not to stop treating, but in the event that they're in that state, they cannot make decisions and that their situation is dire, they would not want to have certain treatments happen or their shift to be focused instead to comfort. So the most common types of advance directives are a living will or a durable power of attorney for healthcare medical power of attorney. Within advance directives, I would say beyond that is forms where the patient themselves can write out specific things, write out specific requests that they have, and they can write as much as they want and make it as detailed as they want. These are state specific. You can refer to the Department of Health and Human Services, and it's recommended to have a copy given to the proxy, to a backup proxy, to clinicians, as well as an attorney. Most importantly, whoever is designated as the attorney for healthcare should definitely have this conversation with the patient themselves. And the patient should make sure that whoever they do designate will actually honor their wishes. This is a conversation I've had oftentimes when I was doing outpatient palliative care. I've asked patients, who are they choosing? My second question is always, will the person that you choose honor your wishes? If the answer is no, even if it's their spouse or their child, I always encourage them to choose someone different, because sometimes it's difficult for that person who's so close to them to honor those wishes if they are different than the wishes that they have for the patient themselves. It's definitely also important to keep the original safe but easily accessible, and patients can even carry a card stating that they have an advance directive and where it is actually located. So a living will reviews future healthcare decisions when a patient with advanced illness becomes unable to communicate their wishes or make informed decisions about their healthcare. It goes over the types of medical treatments the person would want or would not want, and it identifies a legal representative, a surrogate, a proxy, and provides general guidance about what treatment an individual would want or not want. It's important to know that the living will is a legal document, and it's only used when somebody has an incurable illness and they're unable to communicate or understand their medical care. So this can range from general to specific wishes. So like I said, it's as descriptive as the person wants to be when they're filling this out. It's a legal document, they're not medical orders. And a competent person, a person who's able to make their own decisions, can revoke their living will. This living will can be changed or revoked at any time if the patient is competent and able to communicate. It's more limited than the durable power of attorney for healthcare, though. So something to keep in mind is that the durable power of attorney for healthcare can actually essentially decide what medical treatments and options as they see fit, because they're the ones who would know the patient the best, given different situations, how that person's wishes would be interpreted. So that's something that can be very confusing to think about and keep in mind, but ideally this is why it is so important that whoever the person designates as their durable power of attorney is someone who really knows them the best and will honor their wishes for exactly as they wanted. So a lot of the different things that can be included on these wishes can be things like dialysis and things like IV fluids, having tube feedings into the stomach, and also artificial life support, such as ventilators. So following with the previous statement, we'll now move on to a little bit more about what the durable power of attorney for healthcare is. So this is a legal document in which a person names, a patient names a person to be their proxy or agent to make all healthcare decisions if they become unable to do so. This is usually part of an advance directive, but it can be a separate document, and it can be broader than only healthcare decisions. So as you know, that you can also have somebody who's a financial power of attorney. The document that we're talking about, though, is the medical power of attorney, and the proxy can be whoever the patient chooses, but like I said before, it should definitely be someone the patient trusts to honor their wishes. It's also recommended to have a second person because at the end of the day, what if something happens to that primary person who is named? The proxy can speak with caregivers. They can make decisions based on previous conversations. And if the patient's wishes are unknown, which ideally they are known and that's why they were chosen as the proxy will decide based on what they think the patient would want and their assessment of the patient's best interest. The proxy cannot be a physician or nurse providing professional care to the patient unless the proxy is a close relative. So that's where it could become a conflict of interest. It's very important, and that's why there are ethics committees in place for this sort of thing for patients in the hospital. So a lot of you may be familiar with the terms most, most, and post. And generally speaking, this refers to the M being medical, the P being physician, and the second part, O being the orders, and the rest of it really being life-sustaining treatment. So that is a form that is a medical order rather than a legal document, as opposed to advance directives are legal documents. Advance directives are legal and they guide the care, but the medical order are the most, post, and most, and post because they're physician's orders. Oops, sorry. And I see a question here. Can a minister serve as a proxy? Yes, if they're not, that's a very good question, actually. If it's a minister of the patient, I'll have to find out for you on that, but I think that's a very good question to comment on because I think that it's something that we can follow up on because I know there might be some people who feel more comfortable with that compared with others. So, sorry, my screen is frozen. Uh-oh. Oh, there we go. Okay. Worried about a technical issue. All right. So the physician medical orders for life-sustaining treatment, most commonly seen as PULSE. This is that bright pink, highlighter pink form that I'm sure a lot of you are very familiar with. It summarizes the patient's wishes in the form of the medical orders that specify specific medical treatments when a patient has advanced illness. Somebody had a question about the copy of the presentation. I'm happy to provide a copy of the presentation, and I believe this is also recorded, so you are welcome to get a copy of the recording as well. So the PULSE itself is not an advance directive. It is a physician order. It's an actionable medical order that becomes active upon signing by the patient or the patient's proxy, as well as the physician, regardless of the patient's cognitive status. And this can be used in emergency situations. So I think it's really important to keep that in mind that this is a more specific document compared to the advance directive. It's a more broad term because the physician order for life-sustaining treatment really has to do with being resuscitated, having CPR, being intubated, and the more aggressive kind of care in the event of someone dying and how they would like to be revived or not revived. So in acute care settings, patients who walk into the hospital and have nothing else specified as a default are what we call a full code. So if a full code patient stops breathing or their heart stops, which essentially means that they have died, CPR will be initiated unless specified otherwise. DNR as an order means a natural death will be allowed to happen in the event of a cardiac or respiratory arrest. DNR does not mean do not treat, and that is definitely something that's a common misconception in the community. Some states and hospitals actually require for a new DNR order to be done at every hospital admission. OOH DNR is used when a person does not want to be resuscitated if they are outside of the hospital, but in the hospital setting, they would like to be resuscitated. Without a physician sign out-of-hospital DNR order or POLST, emergency crews perform CPR. So this is why that POLST form is a bright pink, highlighter pink, because it's always recommended to have that on display on a refrigerator so that if 911 is called, EMTs will honor that physician order. Another question here, when is the POLST put into place? That's a very good question. POLST, as opposed to advanced directives, I would not necessarily say that everyone over the age of 18 should have a POLST performed. I think the general consensus among the community is when someone has a life expectancy of less than 1 year. Definitely when they're going on hospice, it is 100% recommended that they have some kind of POLST preferences. I don't know if you guys are aware, but actually to be on hospice, you are not required to be DNR. You actually are allowed to be full code. It may seem like an oxymoron because it's in some ways that you're thinking it's going into hospice, but it actually helps to honor the patient's autonomy and give them some more time to really think about what that entails. So I recommend a POLST for someone who already knows and has had that discussion with a physician that perhaps in their stage of life with their conditions, doing something like CPR, being on a ventilator is not going to ultimately help them as much as hurt them. So there's definitely patients who, depending on their condition, it is really futile to do CPR or intubation because ultimately for some patients, even if they go through CPR, they go through being on life support with a ventilator, they will either not survive ultimately or come out surviving with a significantly lower baseline than they did before that acute event. I always encourage for most stage 4 cancer patients, as well as end-stage organ failure patients, to definitely have a POLST. And those are also the categories of people who end up having a life expectancy of less than 6 months and are hospice eligible. Otherwise, the advanced directive is the more important conversation to have, and the POLST to really be specifically tailored to those that have a shorter prognosis, because we want to make sure we avoid the unnecessary CPR and life support and being on a ventilator if that's something that the patient would not desire, as well as like after having that conversation with the physician. And that's why this is a physician order, because the intention is that the physician is having this conversation, although the physician's signature is required, but the conversation doesn't have to take place with the physician initially. A social worker can definitely do the POLST, and that's obviously something that we do in hospice, especially as a social worker may initiate that conversation. But in order for it to become a formal physician order, the physician order does need to review it with whoever had that conversation and ultimately sign it. Ideally, the physician is also involved in the conversation, but it's not a requirement. Okay, so there's a lot of different resources for advanced directives. These are just some of the many, many resources available. What's not on here is the one that I personally was saying that I recommend and I like the most is the Stanford one. I can also include that when I send a copy of this presentation because that one, and actually I could even show it to all of you right now really quick because I really like the way that it looks as far as the font and so forth. As you can see, it says, you visited this page many times, showing you how much I really like this one. So just already looking off the bat, it is very large font, it's very easy to read, and it breaks things down really easily. And that's why I really love this, this form of the advanced directive. It really breaks it down so easily. It's short, it's only 12 pages. Some advanced directive forms are less than 2 pages, but I feel like they're very small font. They don't really break it down as easily. And so it really goes over step by step all the different life support treatments and really puts it in a way that most people can understand. So that's why I really like this. And ultimately, at the very end, you can take this and make it official by signing it and having either witnesses or a notary. So it's something that very easy to get. I mean, as you can see, I always just write Advanced Directive California when I Google it. And as you can see, I've visited this page many times, but this is a savable PDF that you can print out and you can utilize. And I really like this. Yeah, no problem. I'm happy to share it. All right, so let's go back to our presentation here. 5 Wishes is also a very popular one, but I believe you still have to pay for it. So that's why I like the one that I showed you, because it's free. Everything free is always nice, right? All right, so patients are not required to have advanced directives or an out-of-hospital DNR in order to receive hospice care. So like I said before, it is actually not a requirement. Hospice staff will discuss the importance of advanced directives in preserving patient choice. Typically within the hospice team, the social worker initiates this conversation, and they can employ, involve the chaplain or spiritual counselor as well as a physician to have more extensive conversations as well. And hospice can provide training on advanced directives and having these difficult conversations. So starting the conversation. So you've finally decided, okay, it's time to talk about this with mom and dad. It's time to talk about this with my siblings. It's time to tell everyone around me what I actually want. Talking about end-of-life care can be really difficult, but it's important to remember advanced care planning. It's a recurring conversation about the patient's goals, values, and treatment preferences. You have to really keep the focus on the patient, not the conversation facilitator. It's also important to include who's going to be the medical power of attorney and making sure they're involved in those discussions about advanced care planning, because if everything's written down, everything's done, but that person who's designated the medical power of attorney was not there, it didn't happen, because they can say this is completely false, I wasn't there, and so on and so forth. When possible, definitely have these conversations early in the disease process when the patient is mentally and emotionally healthy. This is why it's especially ideal to do it before somebody has a huge new diagnosis or disease process, because that is when they're most mentally and emotionally healthy. But also keeping in mind they can change their mind at any time as things come about. There are a lot of readily available tools, and there's trainings to make these difficult conversations easier. So one of the things that I like, and this actually comes from a study that was done with oncologists in the setting of breaking bad news among cancer diagnoses. This is called the SPIKES protocol, and I'm sure a lot of you are familiar with this. This is a really great acronym to help with setting up the conversation of advanced care planning, a new diagnosis, something difficult, or essentially the way that they describe in this study, how to break bad news. The S stands for setting. It's really important that when you're having this conversation, it's not in a busy location that's very noisy, but somewhere private ideally, or somewhere quiet ideally, where you can sit with the patient and a family member or confidant. So especially in the hospital setting, this is where we have like a family meeting, and thankfully in the hospital setting, there tends to be like waiting room areas, and that's where we may end up using it, or we may use the patient's room if it's private. Making sure to plan ahead is also important, and knowing the patient and situation and gathering information and not just walking into it. P is for perception. First, finding out from the patient, what have they been told? What do they already understand? Do they actually already know a lot of what you're going to be coming to talk to them about? Making sure you know where they're coming from first before you share the information with them, because you don't want to drop a bomb, quickly without knowing where they're already at in the stages. I is for invitation. So most of the time when you ask the patient for how much they want to know, most of the time they'll say they want to know everything or they want to know most of it. But even if they say yes, it is important to ask, because they will always appreciate that you took the time to ask, that you're respecting their willingness to be involved in the conversation. Sometimes, especially in certain cultures, the patient will say they don't want to be in the conversation. They actually defer to another family member to not only receive all the information, but to also make the decisions for them without their knowledge. This is very common in a lot of the different cultures. I'm sure many of you have experienced this. It may be something that on a personal level you may feel, oh, well, the patient needs to know. But if the patient themselves are deferring, that is perfectly acceptable. It just needs to be documented that they are deferring it to a family member. It's something that I always say, that if I hear the family says, oh, don't talk about hospice, or don't talk about the cancer, or don't talk about this in front of my loved one, we always start off by saying, well, did your loved one express that to us? Have we already asked? And if it was already asked and documented, we're good. We can move forward. But if it wasn't, and they're just trying to be protective, we still have to let them know, that your loved one is still competent and able to make decisions. So we do need to ask. And most of the time when that does happen, that they say, oh, I'm the one making decisions, most of the time the patient does say, yeah, I don't want to have this conversation. Please talk to my son. But then at least you've asked, you've documented it, and you can move forward. Then K is for the knowledge. This is where you're essentially dropping the bomb. This is where you're talking about the cancer diagnosis. You're talking about the advance directive. You're talking about the pulse. It's important to share this information clearly and compassionately. It's also important to not use medical jargon. This is basic information. It's also important to share the information, but then stop talking and just listen and let them talk to you about how they feel. If any of you have seen Breaking Bad, one of the things I really like to give an example is in the first episode, the main character, Walter White receives his lung cancer diagnosis. And the way that the episode plays out is he hears the lung cancer diagnosis and he does not hear anything else. And that's part of what may definitely happen in this case, and that's why it's important to have other people in the room who can help support, but also to give time for them to respond to you and to tell you what they're hearing and how, the next one, E, what their emotion is. And also for you to provide empathy with your body language and your words. It's important to allow them to have emotions. It's also important to offer them support statements like, I'm sorry we're having this conversation. It's okay to be upset. It is important not to say, I understand what you're going through. No matter what, even if you've literally had a very similar situation, don't say you understand. It can definitely evoke a lot of anger and resentment. It's important to just acknowledge their emotions, name their emotions, and let them know it's okay to feel that way. Sometimes we as clinicians can get very flustered if we are taken aback by someone's response with anger or certain emotions. Instead of responding with more of that same emotion, we as clinicians should just acknowledge the emotion and say, I see that you're angry, or I see that this is making you upset. That will help to calm down the situation better than anything else we could come up with. Sometimes we instinctively become very defensive. It's important to not do that. It's important to calmly acknowledge the emotion they're conveying to you. And then finally, summary. You just gave a lot of information. You just had a very huge discussion. You want to summarize the conversation. You want to make sure that they heard the important things that you were relaying, as well as planning for the next visit or conversation. Another thing that's really good is remap. And this is first by starting out with reframing. So if there's a current decision, what was it made in context? Finding out the patient, family, profession, understanding what is your understanding of what's been going on in your hospitalization, what's been going on that brought you to this office visit, and so on and so forth. And then reframe the statement in question. Given the circumstances, is it okay if we talk about next steps? So that's kind of like the invitation from the previous one. E is for expecting emotion. So don't ignore the feelings or emotional reactions. Observe and acknowledge them, name them. I cannot imagine what you are feeling right now. And allow for silence. Silence is okay. It may feel uncomfortable, but it is okay. M is for mapping out the future. Do not rush this step. Look at what the patient's goals are. Finding out what the patient's goals are can help for the next step. Maybe they say that, even though this is a really aggressive treatment that I'm going to be doing, it's really important for me to go to my daughter's wedding next month. And if this treatment can help me get there, that's why I want to do it. There's going to be specific situations that are really going to help in guiding what those decisions are going to be. And then, of course, finding out what are the unacceptable situations for this patient. Are there any absolute thresholds that under no circumstance they would want to be intubated, under no circumstance they want to be in a nursing home, and so on and so forth. A is for aligning with values, repeating or rephrasing the patient's caregiver's values and goals. So making sure that you're conveying back to them, this is what you're hearing are the most important things to them. You know, Mr. Smith, I heard it's very important for you to get to your daughter's wedding next month. Maybe even providing some suggestions of things like, you know, we don't know what tomorrow will bring, but maybe it would be a good idea to talk to your daughter about having some kind of private ceremony with you present, because we don't know what's going to end up happening. And I'm sure you guys have seen all over the news and in different articles, a lot of different wedding ceremonies that have taken place in the hospital for this exact reason. So it's really important to acknowledge those goals and really see how can you help to support them to reach those goals. And then finally, P, planning treatments and care that matches the values. So given that you would like this, here are your options. So I don't know if there's any physicians on here, but just as a FYI for all of you, I mentioned before that there is a reimbursement for advanced care planning. This has been, in a way, an incentive for physicians to be able to do advanced care planning. I'm going to admit to you, I don't think the physician community at large does a very good job of this still, even though we now have this reimbursement, but there is a reimbursement in place. And I also think there's a lot of physicians who don't even know that it exists. So that's part of where they may not have an incentive to do that to begin with, is they don't know that spending that time, you know, especially fitting it into their office day, they can actually make it, you know, a reimbursable visit to do that. And finally, I just want to give this closing thought from Dr. Ira Bayek. Dr. Ira Bayek was the founder and chief medical officer for the Providence St. Joseph Health Institute for Human Caring, which is located in Torrance. And he said, I have an advance directive, not because I have a serious illness, but because I have a family. Now I'm going to take questions, although we are at exactly 1 p.m. Let me check the chat box. Okay, I don't see anything else. But Sue, would you prefer then to ask questions or to put in the chat box?
Yeah, they could put it in the chat box.
Thank you. Anybody have any questions? The recording, I believe they will, Sue and the team will be sending out, and PowerPoint, I have a PDF form that I can probably send to Sue as well. Okay, so Amber had a question. Can they use the California directives form even if they live in another state, or should they file in state specific? So that's a very good question that I can follow up on. I like to use that California form. I think that when it comes down to it, the nuts and bolts is the same. So maybe even still using that as a guide, even if they have a state specific one, is really nice. But I can follow up on that question, as well as there was another question about the minister. So I'm going to follow up on finding out about the minister question and this question and provide that when I send the form, the presentation. What role do physicians want the clergy to play in advance directives? Okay. Oh, another one. Okay, so let me just address this question. So the role of the clergy, so I'm a little bit biased because I'm a hospice medical director, so I, obviously work with chaplains all the time. So I like having the chaplain and social worker. I like that interdisciplinary involvement, so I always recognize and acknowledge that. But I think that the clergy overall are really underutilized, and I don't know if a lot of my fellow physician colleagues realize that there is so much value to spiritual counselors for patients who are expressing their wishes. I mean, I'll tell you, even today, I was talking to one of our teams because there was a patient who just got admitted on our service who's full code. And when discussing further with the patient's medical decision maker, the patient's medical decision maker said that it's for religious reasons that she actually wants full code, because she felt that when God felt it was time, the patient will die. And so she has to do everything in her power to support life-sustaining treatments for that reason, which I've definitely worked with some fantastic chaplains who've helped to describe a way that doesn't take away hope and doesn't take away, how they feel about their religion, but helps to support them and supplement that conversation in a way that is really not something like I as a physician can do, our social worker could do, our nurse can do, and it really has to come from that spiritual counselor. So I think that that's also part of the thing too, is educating our physicians in the community about the role of the clergy so that we can involve them. And I would encourage you in the community to bring that up with your, with maybe the people that you interact with, and let them know that you can help support a lot of the things that that they're going for, and encourage them to ultimately have those advanced directives completed, having a pulse completed, and so forth. I hope that helps to answer your question. Next one. Oh, this is a nice shout out. Thank you, Gavin. Wow, this is a really nice shout out. Thank you. I appreciate it, Gavin. All right, any other questions? All right, I don't see any other questions. So thank you all. And I'm going to follow up about the question about the, sorry, I just want to make sure I write it down. The minister serving as a proxy. And the other question was the Stanford form for other states. Yeah, thank you guys.
Right. Thank you, Dr. Naderi. I appreciate you sharing your wealth of knowledge and for the very informative presentation today. Thanks for joining us, everyone. I hope you all got some good information and are able to take back some good knowledge with you and share it with your community, your families, and your friends, as well as your patients.
And I would like to thank you, Dr. Naderi and Gasia and Vitas, for putting together this wonderful presentation. And I'll be editing the recording together, and I'll send it out to all the participants. And if you would like a CEU credit, please email event@onegeneration.org, your name and your email address, and we'll send you that information. Thank you, everyone.
Thank you.